Hello, everyone. My name is Grace Shie. Welcome, and thank you for joining Mayor Brown's 1000 series, focusing today on Brexit. 1000 is a Mayor Brown series that addresses the top 10 issues employers are navigating during the pandemic. Today, our focus is on Brexit. Last week, for part one of this series, we discussed the issues that employers need to address for their EU national employees in the UK. Today, in part two, we focus on the other employee population, that is, UK nationals working in the EU. We're in a countdown phase right now, with the end of the transition period being December 31st, 2020, only a few days away. As of January 1, the UK will no longer be part of the EU single market. What can employers expect for their UK national employees currently in the region? And what can they expect for prospective future hiring in the region? We will address the top 10 issues for employers within this context, with a focus on three countries: France, Germany, and Ireland. And if you can take us to the next slide, these country discussions will bring to life what the post-Brexit era brings for UK nationals in the region. So you'll hear from my colleagues Julien, Vanessa, and David on these countries. During our session together, if you have comments or questions to put forth, please feel free to use the chat box, and with the time remaining, we will address them at the end of the presentation. Next slide, please. In terms of our agenda and the top 10 issues that we've laid out, we'll first address some of the macro principles for UK travel, work, and residence in the EU, and then proceed to discuss the country implementation and country examples with our colleagues in France, Germany, and Ireland. All right, so issue number one. Next slide, please. And really, this is that macro question I raised earlier. How will UK nationals travel to the EU once free movement is ended? Next slide. For those of you who joined us last week, you will have heard the date December 31st, 2020 again and again, because that is the end of the transition period. And when we invite Julien and Vanessa in particular to speak, we'll understand that the end of the transition period is also significant with respect to how UK nationals will be treated in their respective countries. And that date is a fixed point in time with respect to how the laws will treat arrivals pre and post that date. Between now and the end of the year, free movement remains available to UK nationals. But come that date, travel to the EU member states by UK nationals will be subject to the national laws of each member state country. What we expect to see, and again what we'll see come to life with France and Germany in particular, are that UK nationals will be treated as third country nationals, but with favored status. And for purposes of our discussion, third country nationals refers to non-EU, non-EEA, non-Swiss nationals. With favored third country status, UK nationals will be expected to engage in visa-free travel to the EU countries, but subject to limitation per the rules of each member state. And if there's a need to stay for over the visa-free period, which is 90 days, then likely additional travel documents in the form of some type of visa or entry clearance, and possibly a residence permit permitting that longer term stay will be required. Next slide. Visitor travel. Visa travel is a favored status. There is no requirement for UK nationals to visit an embassy to apply for a visa label in their passport. But visa-free or visa waiver travel does come with limitations. One, the activities for a visa-free visitor are limited to those that are permitted for short-term visitors. So in the employment or business context, Short-term travel is permitted for someone attending a business meeting in France, for example, or attending a conference in Germany. So for any type of business travel to the respective countries, a review and consideration of the national legislation of that country is required, because each country may have a different scoping as to what's permitted for visitor travel. Next slide. What's on the horizon for visitors, not just for UK nationals, but for all visitors, visa-free visitors to the EU, is the introduction of an online registration system. As you'll see here, the European Travel Information and Authorization System. Several countries have a similar online registration system for visa-free travelers. The United States has ESTA, E-S-T-A. Canada has a system. Australia has a system. The EU states are following with this online registration system, where visa-free travelers do have to log their status so that the system can confirm you are in fact eligible to travel into the EU as a visa-free traveler. So we do expect that this will also apply to UK nationals. Next slide, please. So we just discussed travel into the EU. What about work, employment of UK nationals in the EU? Next slide. As a general macro rule, working in the EU will require approval by the host or destination country. This will be very different. I think everyone has been planning for that with the end of free movement, but UK nationals will now need to apply for some type of approval to work in the country. There will be some exceptions for those covered under the transition agreement, which Julien and Vanessa will speak to, but come post-Brexit, approval will be required. And for longer-term residents in the EU, some type of approval, typically in the form of a residence permit or residence authorization, will also be required. And to obtain approval for work in the EU, each member state will have its own rules as to what work permit categories may apply to UK nationals. So the same type of analysis that you as an employer currently engage in for your US hires, your Canadian hires, your Australian hires will also apply to your UK hires. And typically, the criteria that each country looks to include: what type of job position are you hiring this person into? What type of role? What are their work activities? How long do you plan to have them employed or assigned to work in not just my country, but also the full Schengen area? Where is the employment contract? Where is this employee going to be payrolled? Do they have the required qualifications for the role? Some countries have a bachelor's degree requirement. Others have a number of years of experience requirement. And there may be other categories that look at experience with one of the companies within a multinational organization. That type of analysis will need to be conducted for UK nationals. That is an overview of travel and work and residence in the EU for UK nationals and what's to come. But let's look specifically at France and Germany in the next section. So, Julien, we just talked about the general principles that will apply to UK nationals. Specific to France, what requirements must UK nationals now meet to reside in France? And this is a bit of a two-part question. Both French UK nationals already in France and looking to stay in country beyond the end of the transition period, as well as new arrivals sometime next year. Over to you.
Thank you, Grace. And first of all, good morning, good afternoon, and good evening to everyone. Yes, you're right, Grace. For France, you have to distinguish two situations. Either you are a UK national who resides in France before the 1st of December of this year. In such a case, you are eligible to apply for a special withdrawal agreement, which allow you to reside in France. But you have to apply for this before the 1st of July of next year. In fact, UK nationals and their family members are required to apply as soon as possible online. There is, we mentioned on the slide, the email address of the site where they can do so, and this is an online service meant for British citizens, very friendly user for British. So we really recommend that UK nationals in these situations apply as soon as possible. Second situation, you do not reside in France before the end of this year. In such a case, you have to apply for a student residence permit at the prefecture, which is let's say obstacle race in France. But you have to follow the regular process. And in any case, and this is maybe something that you have to remember, in any case, all British citizens living in France will need to hold a residence permit as of the 1st October of 2021, whatever the date, their arrival date. Next slide, please. Let's now elaborate a bit on the features of these two kinds of residence permit. You have the withdrawal agreement residence permit allowed to an accelerated process. So the application will be accelerated and all the rights of the individual will be maintained. So the work status, the health insurance and so on will be maintained until the residence permit be delivered. For that, you have to meet some criteria, of course. One of the four that we mentioned on the slide. So either you carry out a professional activity, employed or not employed, or self-employed, or you are registered as a job seeker. Second criteria, you have sufficient resources to live in France, including having health insurance. Third criteria, you are a student or you are undergoing vocational training. And again, you have to be subject to benefit from health insurance to apply. And last category, focus on family members of the British citizen who are based in France prior to the 31st of December. And we have, of course, a right of residence, of course. So this is the ideal process for the UK nationals. Now you have standard citizen permit, which, as I mentioned, is the regular process to apply, and it will last roughly 4 months for the prefecture to deliver the permit, if, of course, the prefecture decides to deliver it. And on the criteria of delivery, it will really depend on your situations. Of course, the criteria, it will be easier to get a permit if you have some connections, family connections in France, and if you are in a situation where you can, for instance, find a new job very easily. Next slide, please. Last, on this residence permit, we are talking about the duration, and again, we have to distinguish between the situation where you arrived before the 31st of December and the situation where you arrived after. In the first case, you have again to distinguish two sub scenario. If the UK national resides in France for less than 5 years, in such a case, it will be eligible to 1 to 5 years residence permit, depending on the personal circumstances. And if you reside in France for at least 5 years, then the individual will be eligible for a permanent 10 years residence permit. When you arrive, and again, it is normal because UK national will be considered as non-EU nationals. If you arrive after the 1st of January 2021, in such a case, your duration of residence permit will really depend on different factors, such as I mentioned, if you get some relatives in France, if you get an employment offer, or the type of study that you carry on in France.
Thank you, Julien. So if we go back to the prior slide, Chris, I think one of the major points that we're getting across is, even though D-Day, as I would call it, is the end of this year, December 30th of 2020, those employees who are already in France actually have until July to apply. They simply need to have arrived in France or the end of the transition period. They still have a bit of a buffer of time to apply for this special withdrawal agreement residence permit. So that is good news for those who have not yet acted. Thank you. So let's move on to the next issue. Thank you. And with that, we'll turn to Germany and ask Vanessa to speak to what the end of free movement means for UK nationals in Germany. And here we'll pivot a bit and focus specifically on UK nationals who are in country and what this means for them in terms of both residence and work in Germany.
Thank you, Grace. And yeah, hello, everyone. So in Germany, if you're a UK employee and you're living and working in Germany on the 31st of December 2020, your status will basically be frozen. So you will have the same rights you had before Brexit. And if you're a UK national, the procedure is pretty much straightforward. You must obtain a new residence document. But the process is quite easy. All you have to do is you have to basically report that you are residing in Germany to the Foreigners Authority until the deadline of 30 June 2021. So if you are absent on the 31st of December, this is not detrimental if your absence does not exceed a maximum of 6 months per year. So if you're going on holiday, for the Christmas vacation or something like that, it's not a problem. You will also be eligible for that new residence document if you are a family member of a UK national. The procedure may, though, be a bit different for you, and I will go into details on the next slide. So next slide, please. So there's one special case I would also like to mention. It's the frontier workers. These are people who are actually commuting from the UK to Germany. So they may be commuting for 1 day per week or for 2 days per week. So they have their main residence in the UK and they come to Germany to work on a regular basis, but they're staying in a hotel or flying back the same day. So if you're a frontier worker, you will have to apply for another document. So that document will allow you to actually continue your commute to Germany to work there. So I already talked about the family members. So if you're a family member which is not covered by the withdrawal agreement because you're not a UK national, different procedure applies. You may be a third country national who is already in Germany and who has a German residence or permanent residence card. If that is the case, you have to do nothing. You will just be contacted by the Foreigners Authority and you will be issued a new residence document. Australia, Israel, Japan, Canada, South Korea, New Zealand, or the US, you will not require a visa to travel to Germany. If you are a UK national and you move to Germany after the 1st January, you will not be covered by the withdrawal agreement. So what you will have to do is you will also have to apply for a visa depending on the length of your stay. I think Grace talked about this already. And once you are in Germany, what you have to do is, if you're a UK national arriving after 1st January or if you're a third country national, you also have to report to the Foreigners Authority by the deadline of 30 June 2021, and you will receive your new residence document. Next slide, please. So obtaining that residence document is actually, it's fairly easy. Of course, the Foreign Authority is entitled to check whether you actually fall under the withdrawal agreement or whether you're a family member of someone who is subject to the withdrawal agreement. And they may also ask for documents providing evidence that this is actually the case, that you were living in Germany, working in Germany on 31st of December, or a family member. So they may ask for tax statements, salary statements, etc. The new residence document, this will be in form of a check card, and it will be valid for a minimum of 5 to a maximum of 10 years.
Thank you, Vanessa. If we could go back, Chris, a couple of slides to the first, that's it right there. And just in terms of comparison with France, similar to France, for those who are already in Germany, they actually have until June 30th to complete this online reporting. So even though December 30th is right around the corner, there is still a bit of buffer for those who are a bit behind. And as Vanessa mentioned, because December 31st, I've been saying December 30th, I mean December 31st, the end of the calendar year, if people are home for the holidays and not in Germany at that time, it's good to know that they will still be able to proceed with this online registration as proof of someone who has arrived in Germany before the end of the transition period. Thank you, Vanessa. Moving to the next question. We turn back to Julien in France. You previously talked about how a UK national may maintain or continue residence in France or obtain secure residence in France after Jan 1. What about working in France? What is expected of UK nationals who wish to continue working in France or will be seeking employment in France next year?
Yes, thank you, Grace. Here I distinguish two types of UK nationals. Those who hold either currently a contract, an employment contract, or who have an offer letter in hand to work in France, but to work in France before the 31st of December, which is, I think, on the second option, maybe a bit theoretical because generally you start working at the beginning of the month. But if you are a current contract holder, in such a case, it's very easy. You will not have to, you will not need any work permit, but you will just need to apply to the withdrawal agreement, as I mentioned earlier, that allow you to reside in France and to work in France, so within the accelerated process. If you benefit from an employment offer letter that will give you the right to work in France as of 1st January 2021, sorry. There's a bit of typo. Normally, you need to apply to a residence and work permit under the rules of in place for non-EU nationals. So you will not be treated differently than other EU nationals, non-EU nationals, sorry. Next slide, please. And for prospective employees, so people, UK nationals that would like to work in France, because we have a long vacations, 5 weeks, and we can have two hours break for lunch and so on. You can, of course, apply in France, no problem. But if you have already worked in France, so you are already an experience in France, you will be eligible for a 5 years residence permit, and that you will have to renew at the end, of course. If you have no prior experience in France, in such a case, you will be eligible for a temporary residence permit for only 6 months. That will be renewable once, and provided, of course, that you prove you are effectively looking for a job, so you in some positive actions for searching jobs, and that you have a reasonable chance to being hired within a reasonable period of time. So concretely, it means that you have to show that you have an offer letter or at least some very close contact or constructive contact with employers in France. Next slide, please.
Turning back to Vanessa in Germany, You talked previously about how UK nationals currently in Germany can register online to continue working and living in Germany after the end of the transition period. How will employers employ UK nationals in Germany after the end of the transition period? So new arrivals, those employees who would be traveling to Germany after January 1 of next year for employment.
Yeah, so these UK nationals, they will actually be treated like any other third country national. They are not covered by the withdrawal agreement because they are arriving after 1st January 2021. And so they will be, subject to the same rules that apply to every third country national who wants to live and work in Germany. So to take up employment, you will require a resident permit that allows you to work, and you will have to apply for it at the Foreigners Authority. And so there are basically no special rules and exceptions for UK nationals arriving after the 1st January 2021.
Next slide, please. Thank you. Last week, when we discussed the new UK system post-Brexit, we discussed how employers in the UK may recruit EU nationals graduating from UK universities because of the new scheme that is in place in the UK. So we thought it important to flip this the other direction for employers who have the same question about hiring UK national or UK national students or graduates of EU university. So we'll ask first France, Julien, if you would walk us through employment options for UK students in France. Next slide.
Thank you. I will not elaborate too much on these slides. Just a reminder of the main visas that we have for students in France. So you have the long stay visa, valid as a residence permit for students, and this is valid for 4 to 12 months, provided that you pursue higher education studies. You have also the Researcher's Talent Passport, long stay visa, which allows the holders of a master level degree to stay in France for conducting researches or teach at a university level. So you have these two types of agreement, of visa. Sorry. Let's move on to the next slide, which is maybe most interesting for you. Next slide, please. So,
Chris, if you could go back to slide 26. Yeah. Thank you.
Thank you. So let's imagine that you are studying in France and you want to stay after your graduation. Two situations again. Your employment is secured, which means that you have a promise for working from an employer. In such a case, and provided that you graduate from a French higher institution, you may stay in France. You will, of course, to prove that you have this promise of employment or a work contract, even better, and that you will be paid at least 1.5 times the minimum wage, which corresponds in 2020 to 282 euros. This amount should be the same in 2021 because the minimum wage will not be increased for the next year, given the sanitary crisis. So this is the first situation. Second situation, you are seeking for an employment. So you still you have no promise to work. You need now to request a temporary residence permit, what we call autorisation provisoire de séjour. That will be valid for 12 months. It will not be renewable, and this is this will be issued only if you are seeking employment in France. People that are eligible to this temporary residence permit must have a professional bachelor or master level degree, or be in the process of starting a company, which happens a lot currently in France. So these are the main two situations for staying in France when you are a student.
Thank you, Julien. Vanessa, for Germany, next slide. Thank you.
Thank you. Yeah, so for UK students in Germany, there are no special rules. They will also be treated like third country nationals who would like to study in Germany, and the current rules for non-EU nationals will apply. So they must apply for a residence permit to study in Germany, and the student residence permit, it regularly gives you the entitlement to work for 120 days a year, or 240 half days a year, and for the classic student side jobs. There's a special rule so that foreign graduates, who actually successfully completed their studies in Germany, they may apply to extend their student resident permit by up to 18 months, so that they have time to look for a job corresponding to their new qualifications.
Thank you. We've just talked about working and living in France and Germany, both pre and post end of the transition period. For employers who will be continuing to employ UK nationals or are looking to continue to recruit UK nationals for their organizations in your countries, what compliance mandates do they have to meet? In this case, if we go to the next slide, we're speaking very directly to the subject of right to work checks. Last week, when we spoke specifically regarding the UK, and for those of you who employ in the UK, you know that there is a very specific or prescriptive process by which employers must validate whether new hire employees have the right to work in the UK, meaning that they are legally authorized to work for you in the UK. Each of the EU member states have some laws that address the topic, some legislation more detailed with more specific requirements for employers than others. Julien, will you walk us through that principle in France, and then we will also then ask Vanessa to speak to this topic. And I think for those of you who employ in both countries, you'll see that there is a difference in treatment as to the requirements for employers. Julien?
Yeah. Yes, for France, next slide, please. Yes, for France, in fact, employers are, of course, required to conduct checks to ensure that the to-be employee is fully authorized to work. If we distinguish if we look at the situation, you are an employee currently under the transitional arrangement. The employer will just have to check that you have your passport to evidence your citizenship. So if you are UK, you have the passport UK, there is no issue up to the 31st of December. So as from 1st January 2021, the employer will need to ensure that the British national employees have the relevant residence permit and work permit that we mentioned earlier that allow to work, and then they will need to apply with the validation procedure similar to non-EU nationals. Basically, they will need to declare that they are, to the authorities, labor authorities, that they are employing or going to employ non-EU nationals. So it will be just a declaration and to keep records of any paperwork that evidence that the employee is duly authorized to work and reside in France. In fact, we don't know at this stage, because the government is still thinking about it, we don't know at this stage whether or not there will be some further regulation that will add some more formalities for employers when they want to hire British nationals. it should be either the same as third EU nationals, or it would be maybe easier, maybe that they will keep the option that only declaring the employee and keeping the passport as an evidence. But frankly, given the way it is now, we cannot assess whether it would be an option or the other. In any case, of course, but it is just a reminder, British citizens who fail to obtain their residence work permit or any relevant document to show that they are authorized to work in France could face a dismissal from the company. Next slide.
All right, so I'll continue for Germany. In Germany, employer compliance, actually, it depends on if we're talking about UK nationals who were covered by the withdrawal agreement, or if they arrived after the 1st January 2021. So with regard to the UK nationals who are, legally working for you, for the employers of, on 31st of December, as a first step, there's actually nothing you would have to do. They can continue employment. There's no further actions required. Then when the deadline arrives, 30 June 2021, that is when things change. Until 30 June 2021, as an employer, you just can believe the UK national if he's saying to you, I'm covered by the withdrawal agreement, I'm allowed to live and work here. After the deadline, you as an employer, you should actually ask for evidence of that legal status. And you should ask the employee to show you the new residence document. There's no legal requirement to actually retain, make a copy and keep it with the personal file, the work authorization. But it is recommended to actually make a note in your files that you checked the status of the employee, you saw the residence document, and he's allowed to work for you. There's no need to notify the Foreign Authority if the employment relationship is terminated later. Next slide, please. So for UK nationals entering Germany after 1st January 2021, they are treated like every other third country national. So they require the permission of the Foreign Authority to work. And as an employer, you are actually obliged to check if the employee has the appropriate residence title and work permit. You're also obliged as an employer to make a copy of the residence title and, actually keep it, retain it in your files in electronic or paper form for the duration of the employment. Another special rule is that you're obliged to notify the competent Foreign Authority within 4 weeks of you learning that the employment has been prematurely terminated. So if the employment in the residence title usually relates to a special employment, and if that is terminated prematurely, you would have to inform the Foreign Authority.
So that's very important for employers who already have a system within the organization to validate or to check right to work. Because I could imagine that there are employers, for example, in Germany, where your system has a bit of mapping, and the mapping could currently be set up that UK nationals no need to check or only need to check A, B, and C, when in fact, it needs to now have a bit of, there's a fork in the road in terms of when those UK nationals arrive, so you are asking for the appropriate documentation for the appropriate pool of UK national employees. And that's going to require a bit of thought in terms of how you program your system to the extent that you do have those systems programmed into your overall HR infrastructure. That will be very important. And along with that, there will need to be some training for your HR specialists who conduct the validations, the right to work checks, because I could imagine that for years, they've not had to, they haven't been obliged, to use Vanessa's term, to conduct these 3 steps for UK nationals. And post-Brexit, not only is there a change in terms of the work permits and work authorization and residence authorization required for UK nationals, but there will also be this additional step for employers with respect to the right to work check system. I'm going to pose the same question to David from Ireland. He will speak next about the treatment of UK nationals in Ireland, and we save that for a separate standalone session because of the special arrangements. But in terms of a preview into that, David, will you also answer this same question? Are there additional or new right to work check obligations for employers of UK nationals in Ireland?
Hi, Grace. No, the answer in short is no. The common travel area, which I discussed shortly, guarantees free movement of British nationals into Ireland and guarantees certain rights, including the right to work, and that won't change as a result of Brexit. So really, we are just back to square one in terms of checking the passport and recording on your HR file that you have satisfied yourself that this individual is a British national and doesn't require any further right to work documentation.
Thank you. And with that, let's turn from France and Germany to Ireland. Next slide. If you'll walk us through, David, why it is that Ireland has a different treatment of UK nationals than what we've just seen will take place in France and Germany. There's a bit of history, a bit of a history lesson you'll now provide, and then we can discuss some of the what you refer to as downstream impacts post-Brexit. Next slide.
Sure. Thanks, Grace. I guess given our proximity to the UK, and the historical, political, and the trade ties between Ireland and the UK, we do stand to be heavily impacted by Brexit. And I think one could even go one step further and say, after the UK itself, we are the country most likely to be impacted by Brexit from a trade point of view. And there's concern here about the impact on the Irish economy. Thankfully, as a result of the common travel area, free movement isn't something we're worried about. Under the common travel area, Irish and British nationals can move free and reside in either jurisdiction and enjoy associated rights and entitlements. So the right to work, the right to live, the right to access education, social benefits, healthcare, and even the right to vote in certain elections. And the key point, I suppose, is that the common travel area predates both Irish and UK membership of the EU. So it's not dependent on it, or it's not dismantled as a result of one or both countries deciding to leave the EU. Both governments have signed a memorandum of understanding in which they've committed to maintaining the common travel area in all circumstances, which is positive. The interesting thing about it is that the common travel area, it kind of grew organically from a patchwork of statutory instruments that, if you look at them individually, wouldn't certainly suggest the common travel area that we have today, but collectively they give rise to this arrangement which affords a great amount of freedom. Now, with Brexit, there was a concern as to whether this would be maintained, and there were calls to put it on a more formal legislative footing, and that hasn't happened. So we are just putting our hope in this memorandum of understanding which has been signed. And in fairness, there have been nothing but positive soundings from both governments so far. So we don't see it going anywhere anytime soon. And the key point is that neither Irish citizens in the UK nor UK citizens in Ireland need to do anything else. There aren't any further positive steps required to protect those rights that they have under the common travel area as a result of Brexit. Next slide.
Mm-hmm. Next slide. On slide 35, thank you. And with the common travel area that you've just described and shared with the audience, David, how will that work in practice? Because if the same rights will be preserved and maintained, I can see many different questions, as you've illustrated here, that will that employers will have in terms of travel and work in either direction.
Sure. Yeah. I mean, I suppose we'll just jump in and we'll just go through the kind of practical scenarios that I've prepared. But can I, as a UK national, still travel freely to and from Ireland? And the answer is yes. And you can do that without any additional visa being required. Anybody who's travelled, a UK national who's travelled to Ireland recently will know that there aren't any passport checks for UK nationals coming over here or Irish nationals going in the other direction. And again, we don't expect that to change. There'll obviously be air and sea carriers who expect to see a passport before allowing you to board. So that's just something to bear in mind. But as an immigration requirement, there isn't any sort of travel visa to be in place. Similar to a UK national who needs to work in Ireland, they can do so under the common travel area without an employment permit being required, and that also applies to self-employment scenarios, which is important.
So David, actually on that point then, with respect to the prior question as to right to work checks, then in that case, it's the status quo. Nothing changes in that respect.
Sure, exactly. I mean, as I say, the common travel area has been around for a long time. It does predate EU membership by Ireland and the UK, so it's not going to impact on this whatsoever. So the same right to work checks you would have carried out for UK nationals previously will be sufficient going forward.
So in terms of employers who have those HR systems or the HR infrastructure where there is a bit of mapping as to how to conduct right to work checks in each of the EU countries, that's yet another line to draw in the sand, because while the system may need to reprogram what documents and what validation process applies to UK nationals in the rest of the EU, it's the rest of the EU not including Ireland, where the current set of documents and the current process applies. So it is an analysis that employers need to go through before they recalibrate the right to work check process for UK nationals within each of their EU locations.
Yeah, it is a tricky one, I suppose. We are, as I say, free movement is something that Brexit isn't causing a concern for us, but it's worrying us on every other level, but not on free movement, thankfully, and not on right to work checks. So, in terms of British citizens who are already here, as I've said, they have those rights ring-fenced under the common travel area in terms of access to education, healthcare, etc., and they're ring-fenced by the common travel area. Brexit won't have an impact on them, so there isn't anything that British nationals who are already here need to do to protect those rights. Conversely, as an Irish citizen who's in the UK, the Home Office are telling us that they won't be required to register under the settled status scheme to protect their rights. So that's good news. But obviously, as EU nationals, they are entitled to register under the settled status scheme, but it's not an absolute requirement. Where we do see little changes is where we have British nationals who are in Ireland or Irish nationals who are in Britain, and they have EU family members or non-EU family members. Obviously, the EU family members who are living with a British citizen in Ireland, their right to live in Ireland will be, again, ring-fenced under the EU Free Movement Directive, so not a huge amount of concern there. But if you're talking about a non-EU national who's living in Ireland with a British citizen, they would have derived their rights of residence from the fact that the British citizen was an EU citizen. That's obviously not the case post the end of the transition period, which I suppose throws some uncertainty into the mix. The Irish authorities are telling us not to worry. The rights of the non-EU national family member will be protected, but they will need to go through a process whereby they exchange their current Irish residency permit, which will denote the fact that they're deriving their rights of residence from the EU Free Movement Directive, and they will get a new permit which will denote the fact that they're going to derive their right of residence from free movement under the withdrawal agreement. So their rights won't change, the rights aren't going to be restricted in any way, but they will have to go through an application process to get that new residency permit, just so they're correctly classified in terms of where they're getting their rights of residence from. Similarly, the Irish nationals living in the UK with non-Irish or British family members, those family members will need to register on the settled status scheme to protect their rights going forward. And the final question, just what about British citizens who haven't arrived here yet and are bringing non-EU family members with them? So British citizens, fine, can travel freely, no difficulty with that. But the Irish authorities are telling us that those non-EU family members will have to undergo a pre-clearance application process before travelling. And we don't know the details of that application process yet. We do know it's going to be online. And with every new system, there's likely to be teething problems. There's likely to be a huge uptake in the pre-clearance application process. So there's likely to be delays of, knowing everything else that's gone on with COVID and the pressure that the Irish authorities are under. You're probably looking at months of a delay rather than weeks. So it's just something for your clients and your employees to be aware of if you have a British national who's planning to come to Ireland to work with bringing non-EU family members with them.
Great. And in the interest of time, David, if you could just give us a quick preview, a discussion of the next two topics, which are important to cover.
Yeah, no, sure. Look, I'm conscious of time, but next slide, please, if I could. Just to mention, look, the Northern Irish border it's a huge issue, and the reason why it's an issue is that it will be the only land border between the UK and the EU after Brexit. And as a result of the 1998 Belfast Agreement, which brought peace to Northern Ireland, that border is now invisible. And the concern was that with Brexit, the UK leaving the EU and bringing Northern Ireland with it into their own customs regime, that there would need to be some sort of border between Ireland and the UK. And the concern was that to return to any sort of physical infrastructure or customs checks between the Republic of Ireland and Northern Ireland would reignite political tensions and violence that caused a great number of deaths in Ireland from the late 1960s up to the execution of the Belfast Agreement in 1998. So everybody who's involved in Brexit were very, very conscious of the need to avoid this hard border between the Republic of Ireland and Northern Ireland. The difficulty was how to bring that about. Now what we currently have is the Northern Ireland Protocol, which replaced the previous backstop. Under the backstop, if a free trade agreement wasn't agreed between Ireland or between the EU and the UK, both the UK and Northern Ireland would enter a single customs territory within the EU. What we now have is a Northern Ireland Protocol, which means that post-Brexit, Northern Ireland is going to stay as part of the EU customs regime, which means no need for a border between Southern Ireland and Northern Ireland. Goods can move freely between those two jurisdictions because we're both part of the same customs regime. But it does mean that Northern Ireland, one part of the UK, is part of one customs regime, and the rest of the UK is part of another. So there's going to need to be a border in the Irish Sea to check goods moving in either direction. And that is causing downstream problems. Next slide, please. So I mentioned sausages, fish and chips. That's not what I'm having for dinner this evening. These are real issues. So the EU currently bans the import into the bloc of unfrozen meat products like sausages and plant products like chips, both of which we currently import a lot from Britain, which will be outside the EU after the transition period. So that's a problem in terms of the stocks of sausages in Irish supermarkets and the stocks of potatoes for Irish chip shops to make chips. And at the minute, there is no end in sight or a resolution. We are going to have to find different sources for those products. It won't be Great Britain, unfortunately. And finally, just to mention, there's been a huge spike in Irish passport applications as a result of Brexit, so that's UK nationals trying to get their hands on Irish passports to guarantee free movement. And the issue of UK driver's licenses, there's still 13,000 UK drivers in Ireland who haven't exchanged their UK driver's license for an Irish one. Those driver's licenses won't be valid after the 31st of December, so another potential problem. I think I put it in terms of time.
Thank you.
I'll leave it there.
Great, thank you. Next slide, please. We do have one question that I want to make sure we make time for. Next slide, please. In terms of planning ahead, we have a few points here, a few tips here for the employers on the call, a few significant ones to emphasize. One, you've heard some of the various deadlines from Julien, from Vanessa. Even though the transition period ends at the end of this calendar year, UK nationals already in your countries working for you have a bit of a buffer until June or July, depending on the country, to register and complete the registration requirements of each respective country. So to the extent that that type of communication hasn't been given, it's important to be aware of that additional time, but those very real deadlines to complete the online registrations. UK nationals will be able to travel into these countries, but are subject to the existing Schengen travel rules that apply, say, to US citizens, the 90 out of 180-day rule. I believe employers in the EU are typically very familiar with this rule. What will be different is the fact that that rule, that time limitation for Schengen travel, will now apply to UK citizens. Planning ahead, the second to the last point, can't say that enough. Planning ahead and understanding that as we approach the end of the calendar year, many companies, including our Mayer Brown clients, are preparing 2021 budgets if they haven't already been submitted. And those budgets need to now include the process, the efforts, including government filing fees, potentially and legal fees, that will be required to obtain certain approval documents for those UK nationals. If you typically hire UK nationals for a fall class of incoming analysts and associates, and geographically you typically hire 25%, 30%, 40% from the UK, well, that hiring cost will now look different because that cost will now include the effort to obtain work permits. So that needs to be incorporated into the planning. And finally, as we discussed earlier, reviewing the legal validation procedures. I do want to turn to the question that we've received and ask our panelists, starting with Julien, to opine. The question is, how do you think secondments and international placements of staff will be affected by the new immigration regulations branching from Brexit? I believe that question relates to an employer who plans to send to second or assign a UK national employee from the UK into your countries. So not local employment, but an intercompany transfer, if you will. Julien?
Yeah, that's a very good question because so first of all, currently some employers, either UK or French or German, have some secondees in these jurisdictions. So the first questions, maybe it is not the question asked, but I can maybe just reply briefly on this. Maybe the first question is also to determine whether these persons who are currently in secondment within a A1 certificate, so they are currently employed by their employer, they pay their contributions in their home country. What will happen as of the 1st of January? Normally, it is the case for UK, I know, and it should be the case for France, even though for France there was some authorities that were reluctant to do so, but normally they should remain on secondment and should remain on their own country regime for all the duration of the secondment, even though it lasts after and it ends after the 1st of January 2021. For those employers who want to second after the 1st January of 2021, this is a gray area because they will not be EU nationals, so we cannot benefit from the provisions of the EU regulations. And at this stage, there is no, for instance, for France, there is no bilateral treaty between France and UK, which means that practically this kind of, in terms of secondment, the employee will need to be to pay contributions in the UK and potentially also in France. If there is no agreement as of 1st of January, this kind of people that are mobile employees will need to pay both in their own country and in the host country. But I'm confident that the governments will find a solution. But at this stage, it is the response.
Thank you. And Vanessa, you get 1 minute to also provide the German perspective.
Yes, actually, I mean, it's a similar situation in Germany with regard to the E1 certificate. The legal situation is totally unclear, and so this is something that there's currently no recommendation what to do actually, but to employ locally. That's of course an option. Generally speaking, secondments will of course be more difficult because even if it's like just a secondment, people from the UK, they will still need a work permit in Germany and a residence title. This is something they did not require before, so it will be more expensive and more work, to actually assign someone to Germany from the UK.
And David, based on what you shared earlier, it sounds like no change, status quo, for a transfer of a UK employee to Ireland.
Exactly, yeah. Same old. I sound like a broken record now, but yeah, no change.
No, that's great. And with that, we're just slightly over, but I think we made it in within a total of 1 hour. Thank you to my fellow panelists for joining today's call, and thank you to everyone for attending. Have a great rest of the day.